The question is the amendment moved by Senator McDonald be agreed to. Those of that opinion say aye. Aye. Those against say no. I think the ayes have it. The ayes have it. The question now is that the motion moved by Senator Fifield as amended be agreed to. Those of that opinion say aye. Those against say no. I think the ayes have it. The ayes have it. Clerk? Sorry, Senator Milne.
Standing orders be suspended as would prevent me from moving the following motion: that the Senate calls on the Attorney General to provide to the Parliament before question time today an explanation of his reasons for authorising ASIO raids on Timor-Leste legal counsel and a key witness for pending permanent Court of Arbitration hearings in The Hague. Now, Mr Deputy President, as you would be aware, this is not something that the Greens do lightly. In fact, it's one of the very rare occasions I can remember in my entire Senate career where we have decided that it's important enough to actually have this matter dealt with and call on the Attorney General to make a full explanation and statement. Now, the reason that it is so important is because Minister Brandis is the highest law officer in the land, and he has authorised intelligence agencies to go and to raid a legal counsel who are currently in proceedings in The Hague on a matter that is critically important, of course, to East Timor. But what is at stake here, as is being said in the media, is never before has East Timor taken someone to this arbitration panel in The Hague. Never before has Australia been called to answer questions about spying in a forum such as that. But it's also not just about a treaty, it is about the maritime boundary between Australia and East Timor, it's about billions of dollars in resources, and it's about the resource-sharing deal that former Minister Downer and the government of the time struck and whether it's valid. It's actually a shocking thing that as this negotiation is going on in The Hague, the Attorney General in Australia authorises the raid on those legal officers. Now, I have seen the minister's statement trying to suggest that the two matters are unrelated, but it beggars belief that they're unrelated, that 24 hours after the lawyer has virtually left the country to go and actually work with Timor-Leste in The Hague, we have the chief officer in the law officer in the land authorising a raid on that office to take documents from the office, and at the same time we have a key witness in that proceedings having his passport taken away so that he can't travel to provide evidence. Now, what does that say in a nation like Australia? Who's next, Mr Deputy President? Who else's passport is just suddenly going to be taken from them in a raid so that they can't go and do whatever they intended to do overseas? And there's no suggestion here that the whistleblower who was going to attend to give evidence in The Hague was in any way a threat to national security. This is about big companies and the power of those big companies over government, and the question of the extent to which the Australian government is acting in the commercial negotiations of a company in the situation as occurred in East Timor. So that's why I think it's important that Minister Brandis be required to make a statement before question time as to why he authorised those raids, how it can be justified, if it can be, because these are about the commercial proceedings. At no stage was there any suggestion that the original bugging of the Cabinet room in East Timor was anything other than to assist in the commercial deals that were being done at the time. It wasn't about national security, and it's still not about national security, and it is just beyond belief that the timing of these raids has nothing to do with the negotiations going on in The Hague. And if it can happen on this occasion, what else is Minister Brandis going to authorise for the agencies to go and raid illegal chambers or to go and raid individual homes, take someone's passport. This is important, and that's why I think it is critical that Minister Brandis actually be required to make that statement to the parliament today. It is of grave concern to most Australians, I'm sure, when they wake up and hear that that has been authorised by Minister Brandis, and I think it's important that we get on the record from Minister Brandis before question time today exactly why he authorised the raid on those legal officers and took that passport away.
Senator Fifield.
Thank you, Mr Deputy President. The government won't be supporting the motion to suspend standing orders. It's incredibly important that matters of Australia's national security are dealt with very carefully. The government doesn't believe that it's appropriate to canvass those matters in the manner in which Senator Milne is proposing at this point in time in the proceedings of the Senate. Obviously, Senator Brandis, who as Attorney General has portfolio responsibility for these matters, will look carefully at the contributions of colleagues in this procedural debate. But I just want to reiterate that this chamber does need to be mindful of the long-standing conventions and protocols in relation to the commentary on national security matters. I know that they were protocols and conventions that the previous government took seriously. They're protocols and conventions that this government takes seriously. National security matters have historically been placed beyond partisanship, so the government, as I've indicated, won't be supporting this motion to suspend standing orders. But as I say, the Attorney does pay close attention to the contributions of colleagues in this place.
Senator Wong.
Thank you, Mr Deputy President. The opposition will not be supporting the suspension move by the Leader of the Australian Greens. I do note, however, the statement from the Minister that the Attorney General will pay close attention to what is said in this chamber in relation to this matter, and I would make a number of points. The first is this. This is obviously a matter which has garnered considerable attention in the Australian community. The Attorney General did issue a short statement last night in which he confirmed he was responsible for the issuing of warrants which the Australian Security and Intelligence Organisation later executed on addresses in Canberra. In that statement, the Attorney General asserted that the actions he took would not affect or impede the current arbitration between Australia and Timor-Leste at The Hague. These are important matters. They do go to the integrity of the rule of law, and for that reason the opposition does believe that the Senate, the Parliament, and through them the Australian people would benefit from a statement from the Attorney General on this matter. However, we're not prepared on this occasion to support an interruption to the orderly proceedings of the Senate in the manner proposed by the Australian Greens. We will always, in matters of national security, take a responsible and considered approach, but I again reiterate, I think, encourage the Attorney General to consider the merits of making an appropriate statement to the Parliament.
Senator Ludlam.
Thanks, Mr Deputy President. Look, I rise to make a brief contribution here, and as Senator Milne has said, the Greens do not make these sort of suspensions lightly. It's not conduct that we engage in unless the matter is of utmost importance. And I acknowledge Senator Fifield's comments. I think it would be appropriate for Senator Brandis to join us for this debate, but nonetheless, I acknowledge, Senator Fifield, your comments this morning, but take you up on one issue, and it's the issue, crucially, that goes to the reason that we brought the suspension motion forward, that it is not at all apparent to the Greens, or I would suspect to the general public, that this matter has anything whatsoever to do with national security. I understand and respect the reasons why ministers of coalition or Labor Party orientations wouldn't comment on matters that would prejudice ongoing national security investigations. If ASIS had been exposed bugging al-Qaeda headquarters or wiretapping international organised crime or money laundering syndicates, this motion wouldn't be necessary. But what is at stake here is an accusation, and an apparently well-founded accusation that will be tested at a court of arbitration in The Hague this week, that ASIS bugged the cabinet rooms of the government of Timor-Leste during sensitive commercial negotiations that have consequences in the billions of dollars for commercial players like Woodside, and then by extension the Commonwealth of Australia and the government of Timor-Leste through tax revenues and royalties. That, I would submit, has nothing whatsoever to do with national security. For that reason, the Attorney General should front us today and explain why he has used the most extreme executive powers that are available to him, calling in intelligence agencies with extraordinary coercive powers, serving warrants on people that they are not even permitted to read, detaining legal counsel and key witnesses for a matter of hours without any explanation at all. You are not then able to simply wave your hand and call national security as the reason why a shroud needs to drop. This Parliament, the Australian public and the people involved in these arbitration matters overseas deserve an explanation better than they got last night from the Attorney General as to why covert agencies have been called in to exercise some of the most severe powers that are available to Australian agencies. You can't then come in here and simply claim that national security means these people are not owed an explanation. The very fact that former Foreign Minister Downer, who was the Foreign Minister at the time that these allegations prevail, that ASIS bugged the government of Timor-Leste to apparently advance the commercial interests of Woodside, an oil and gas corporation, that then Minister Downer sets up his own lobbying company and lo and behold ends up on the payroll of that very same corporation. That is the reason that this ASIS operative has decided to take the extraordinary action of appearing as a witness in these arbitration hearings. As it has been said, this is not some junior operative. For all the mud that has been flung at the US whistleblower Edward Snowden, noting the deliberate use of the term traitor by our Attorney General earlier this week, this is not a junior subcontractor who has come into possession of documents. This is a key operative who ran technical operations for ASIS at the time that these allegations are said to have occurred. This is somebody not merely with high-level technical knowledge and competence of the operations that were underway, but it's somebody with a conscience. Our people who display a conscience like that and are willing to go on the public record in defence of one of the poorest nations in the region in their negotiations with one of the richest nations on earth should be protected. They should not be subject to arbitrary intimidation and detention by ASIO at the behest of Australia's Attorney General. Senator Brandis owes it to this Parliament, owes it to the Australian people and owes it to the people of Timor-Leste to front this chamber and explain what on earth he's doing. He's already being compared to former FBI boss J. Edgar Hoover, and that story didn't end well. This appears to be a chilling abuse of executive power. If it is not that, then the Attorney General owes it to us to front this chamber and explain what on earth he's up to.
I was going to go to Senator Faulkner next, Senator Xenophon. Senator Faulkner.
Thank you, Mr Deputy President. I think every senator in this chamber would acknowledge that it is important for the public, the Australian public and of course the Parliament to be kept informed of matters as much as is possible, to the extent possible. That's a principle that all ministers accept. But any minister, particularly those who have national security responsibilities have to be consider also what is appropriate to place on the public record. And all ministers who have national security responsibilities have generally accepted, always accepted, the principle that is outlined in Odger's Australian Senate practice. I rarely quote Odger's, but let me do so this morning. It has been, it says, Mr Deputy President, and it's a very accurate representation of the position. It has been the policy of successive governments that questions seeking information concerning the activities of the Australian Security Intelligence Organisation, ASIO, or the Australian Secret Intelligence Service, ASIS, will not be answered. It goes on to talk about certain precedents and the fact now, of course, that ASIO officers or the Director General does appear before Senate estimates committees and answer questions. So there is a long-standing precedent which every member of Parliament understands, that that ministers have been and should be constrained on what they say publicly about intelligence and security matters. That doesn't mean that a minister with national security responsibilities cannot, if he or she believes it is appropriate, seek the leave of the chamber to make a statement. I certainly did that at times when I served as Minister for Defence. I also, in consultation with other parties in the chamber, used the forum of question time to address important matters that were very significant at the time in terms of the public debate in this country. So I have never known of a situation where a minister who seeks to make a statement would not be given leave of the Senate. I believe, certainly in this instance, if Senator Brandis chose to do that, that would be the case, and it should be the case. But the issue here, Mr Acting Deputy President, is should the Senate make such a demand of Senator Brandis? I've read Senator Brandis's public statement entitled Headed Execution by ASIO of Search Warrants in Canberra, where he makes the point, and I quote from the statement, "The warrants were issued by me on the grounds that the documents contained intelligence related to security matters." I don't know what, if anything, Senator Brandis would be able to add to the public statement he has made. What I am concerned about at this stage, in advance of question time, in advance of the forums of the chamber that are available to us, to put demands on a minister that is suggested in this motion for the suspension of standing orders here. I think that would be a new precedent which I think would be inappropriate for this Senate to agree to. There is a long-standing mechanism for us dealing with these matters. It's tried and true. It has stood the test of time. It should continue to stand the test of time.
Thank you. Your time has expired. Senator Xenophon.
Thank you, Mr Acting Deputy President, and I take note of what Senator Faulkner has said, particularly the responsibilities he's previously had as Minister for Defence, and I note Odger's Senate practice and the constraints placed on those that have the heavy responsibility of dealing with intelligence matters. I think that this debate, this suspension of standing orders sought by the Greens is timely in the context of revelations over the last few months and in recent days about the extent of metadata surveillance of Australian, potential metadata surveillance of Australian citizens, and also the extent to which surveillance powers should be more transparent and accountable. I just want to take issue with what Senator Ludlam said about Senator Brandis, suggesting that there are some parallels between him and Jade Hoover. I'm not sure if he was being serious, but I cannot take that as a serious comment. I think that that is unhelpful to the debate, and I accept that Senator Brandis, the Attorney General, takes his responsibilities in relation to matters such as this very, very seriously. I agree with the comments made by Dr. Clinton Fernandez, Associate Professor at the UNSW Canberra, in an opinion piece published just this morning, where he describes the raids that are the subject of this suspension of standing orders motion, that the raids were designed to seize and confiscate documents believed to contain intelligence on security matters. And I agree with Professor Fernandez that Senator Brandis, as Attorney General, was probably correct to deny that he had authorised the raids in order to impede the arbitration. It is more likely, says Professor Fernandez, that the intention was to see whether the names of Australian spies who had conducted the espionage would be revealed, and protective measures should be taken in advance. I agree with that. We must protect the identity of those that work for our intelligence services overseas, because that puts them and their families at risk. But there are still a number of important matters that are raised in the context of this motion. It simply seeks to suspend standing orders for an explanation. I think the difference with Senator Faulkner's approach is that we shouldn't force the attorney to make a statement at this time. I think simply requesting that the matter will be addressed, and it could be that the attorney will say, I will make a further statement down the track, would itself be useful. But I think that this motion highlights the timing, the importance of this debate in the general community about the issues at stake here. But also I want to make it clear that the Attorney General is perfectly entitled to take whatever protective measures there ought to be to protect the identity of security officers or those intelligence officers working overseas, and to protect their identity. That is something axiomatic, and that is something that I support. But if we get, but I agree with Senator Ludlam that there ought to be a suspension of standing orders. It would be healthy and transparent to debate these issues. I reject any comparisons between the Attorney General and J. Hoover, the former Director of the FBI, and I think that diminishes the arguments in favour of the suspension of the standing order. But I think it is important that these matters be aired and ventilated, but that does not imply, on my part, necessarily a criticism of what the Attorney General has done, but I think an explanation is something that is warranted and justified at this time. That is why, with those caveats, I support the suspension of standing orders.
The question is that the motion moved by Senator Milne be agreed to. Those of that opinion say aye. Those against say no. I think the noes have it. The noes have it.